back to another installment of Empowered Esquire TV, where I empower you with the law and where we have edifying legal conversation. And now, my personal disclaimer, all right? I am a lawyer, but I am the president of the Lawyers Have Lives Coalition, okay? I have a life. I'm a person and I have a personality. This is not court. This is not a courtroom, right? So when I come into this space, this is a space where I'm having a conversation and I may show some personality, all right? That's allowed. By the way, there are attorneys on YouTube that drink in their videos, curse in their videos. Okay, so if me having a little bit of sass is too much for you, baby, this ain't for you, okay? So you guys know I'm not for the long intros. Let's jump right in. This Michael Nowak, aka Brother Polight case, has been ongoing for quite some time. Okay, there have been quite a few court appearances, but thus far, nothing much has happened by way of the case coming to any resolution, right? We have not seen a trial, and we haven't really seen the setting of a solid trial date per se. Now, what has been said is that Brother Polight, I say that with air quotes, is set to plead guilty, right? That is what is being said. Now, for those of you who maybe you're like me and you honestly weren't paying that much attention and you might be behind, okay, allow me to catch you up a bit. So what I'm going to do right now is read from the screenshot that I have of the docket, the most recent goings on in the docket. Am I going to show you the screenshot? No. And here's why. There are 50 million amazing, credible people who have already shown you how to track Brother Polight's case online and how to look at the docket. I believe Let Me See Your Transcript has done that, and I know for sure that Queen's Throne has done that, okay? You can go on to either space. We're not going to reinvent the wheel, okay? So as of July 7th, it was put into the docket that there was a plea set for September 6th, 2023. Okay. Then on July 10th, it was put into the docket that a trial prosecutor has been assigned. Now, for many people, those two things put together are a bit confusing, right? Because first you see that allegedly this is set for some plea agreement or some plea deal, right? But then second, you see that a trial prosecutor has been assigned. So let's take it step by step. Let's start with July 7th and the conversation surrounding plea deals and plea agreements, okay? So a lot of people online have been saying, well, he's going to get this amount of time in prison or this amount of time in prison based upon his plea deal or plea agreement. No one can say that because no one, unless they have the paperwork, which I highly doubt, right? They cannot say that, okay? Let me give you the rundown on how the plea agreement process works. It is a negotiation between defense counsel and the government. Defense counsel and the government discuss, negotiate, and come up with what is called a plea agreement, right? In that agreement, it is denoted what the defendant will actually plead guilty to, what the potential or recommended sentence is for that plea, and then any other additional implications, right? A plea agreement has not been completed until the defendant pleads guilty. One more time. A plea agreement has not been completed until the defendant goes on the record, changes their initial plea, that initial plea in which they pled innocent, which Michael Nowak did initially, right? Changes that initial plea to guilty. At that time, Michael Nowak will say he's changing his initial plea of not guilty to guilty. He will then state what he is pleading guilty to. Why is it important for me to tell you that? Here's why. When you negotiate, there is give and take. In a large plethora of plea deals, You do not see the defendant pleading guilty to the top charge or the highest charge in the charging document because it is, again, a negotiation, right? And in any negotiation, why would the person agree to the worst possible outcome? But understand that it's very likely that, quote unquote, Brother Polight will not be pleading guilty to the top charge in the charging documents. So those online who are speculating that he is going to receive the maximum amount of time possible under all of the charges on the charging document, they're dragging it, okay? It's called a plea negotiation and it's called a plea agreement. Let's take a slight walk down memory lane. Let's take a look at the Brother Polight playlist here on this channel because I want to play the very first video we've ever did on this case. The reason being is I want us to look at the initial charges, right? Talk about what those were so that we can actually talk about the potential outcomes for this plea agreement. Before we do that, remember I said that on July 10th, there's this entry in the docket that says trial prosecutor assigned, right? And they've been saying, well, what does that mean? Does that mean that it's going to trial now and that there's no longer a plea agreement, or what is going to happen, or blah, blah, blah. So there are a number of things that could be happening here. First, the original trial prosecutor assigned may have some reason why he or she can no longer remain on the case. Maybe they left the office, maybe they've fallen ill, etc., etc. Okay, that's the first outcome. The second outcome is that perhaps the government wants to be prepared in the instance that the plea agreement does not go through, because as we discussed, it's not over till it's over, right? It's not over until Michael Nowak gets on the record and pleads guilty. So first possibility, perhaps the original trial prosecutor can no longer remain on the case. Second possibility, perhaps the people are preparing themselves for the possibility of a trial because it is not over until it's over. And let me add for you one more note on plea agreements. They do still require the approval of the judge. So yes, the government and defense come together and they have this quote unquote agreement, but the judge still has to approve this agreement. It doesn't happen very often that judges reject these agreements, but they do. It has happened, right? So you may just be seeing the government preparing themselves for anything that could happen. Shaka Ndugu says, how do we know he pled guilty in the first place? We don't know that he has pled guilty. The docket report says that it is set for a plea. And from that, right, we are saying that according to the docket report, he is set to enter some sort of plea based upon a plea agreement. But again, that may not happen, right? Jelly with the Hanafuda earring says, this would be the third prosecutor on this case, I believe. Maybe. Okay, so let's have a conversation about that very briefly. Is it, quote unquote, normal for a case such as this to have landed on multiple desks? Here's what I will say. Yes, I will say it's not that outside of the norm for this case to have been shifted from one prosecutor to the next. These types of cases may initially land on the desk of someone who does not have as much experience for them to handle the legwork of this case. And then once the case progresses and gets into more of a trial posture, it may very well then be handed off to someone with a bit more trial experience. So we're not totally out of the norm yet. MJ has a question. He's waiting on a better judge. I don't believe the judge has shifted that often, right? And a quote unquote better judge isn't really an outcome here, right? Because when judges review whether or not to accept plea agreements, they're looking at a few things. First, they're looking at, is the plea agreement quote unquote fair, right? So is it an agreement that for the crime charged and for the crime pled to, it is a fair outcome? They're also looking at whether or not the defendant understands the implications of the plea agreement. I have seen plea agreements not go through because it was clear to the judge that the defendant did not truly understand, and they are not going to accept that. And then the third being, The defendant has to earnestly enter the plea of guilty. So if you have a defendant who gets on the record and says, oh, I'm saying guilty, but only because, I want to get out in time for Christmas, the judge will more than likely not accept that, right? Because in all three instances, that plea can be overturned by saying that the defendant's constitutional rights were violated, right? Your constitutional rights are violated if you are bamboozled into saying that you are guilty of something you aren't actually guilty of. A Bit Tad says, I was in my conspiracy theory bag, like he done bought the judge off. Oh my goodness, you always have the funniest comments. Oh, okay, so Shaka meant innocent instead of guilty. So yes, in his initial plea, he said not guilty. And at his arraignment, he entered a plea of not guilty. So here's the thing, Shaka. If you enter a plea of guilty at your arraignment, then your case moves forward towards sentencing. You have said you are guilty. The only way that your case enters adversarial position is if you say at your arraignment that you are not guilty. As Michael, quote unquote, brother Polight Nowak did. B Legend has a question. What's the difference between guilty and no contest? That is a good question. So when a person says that they are guilty, they are saying, I have in fact committed whatever offense I am accused of. Now, when a person says no contest, they are saying, I am not saying that I committed these offenses, but I'm acknowledging that there's evidence against me and I would like to dispose of this case, right? So guilty is, I did this. No contest is, I didn't do it. I'm not saying I did it, but I know there's evidence against me. So they're legally different. Levon says, with the evidence that's already in play, do you think it's likely that Mr. Nowak won't see actual jail time? Well, here's the thing, Levon. The quote unquote evidence that's in play, because remember, we have not had a trial. And this is what I want all of us to garner today. What an attorney says is not evidence. So all we've heard thus far is attorneys get on the record and say things. That is not evidence. We have not had a trial where we've actually seen evidence presented. So that's my answer to that question. Claymore Jones' question. Is it likely that the plea agreement involves at least one of the felonies because the prosecutor said it will require incarceration? Well, Claymore Jones, that is a possibility, right? And that's something we're going to get into next because some of the charges would require SO registry. You guys know what SO is, right? And you know what the SOR is? Okay. Some of these charges would require SO registry. And I have to say that in the beginning of this case, Michael Nowak, aka Brother Polight, he was so adamant about his innocence at the beginning of this case. And so it's interesting to me to consider the possibility that he may enter a plea which would require SO status, that he would agree to plead guilty to being on the SO registry. That's an interesting premise for me, considering how adamant he was about his innocence in the beginning. T. Ben's question. So is there any possibility that he walks free? Well, is there? Well, here's the thing. A lot of things are possible, right? I mean, let's be real. Almost anything is possible. But if he pleads guilty, it is not extremely likely that he would walk free. And there's a reason for that. So the reason being is that when you consider the charges against him and the minimums attached to those charges, it's not very, very likely that he would walk free. He did not serve that much time in the beginning, right? If you guys remember, he was not incarcerated that long before he got released. Now, allegedly, he was released on clerical error. The long and short of it is that he was released, which means whatever sentence he ends up actually receiving, he doesn't really have much time to go towards that sentence. He doesn't have days upon months of time served. So the possibility that he would actually walk completely free is not extremely likely. Quizmatics. I heard Polight skipped his last court date, the one he was supposed to agree to the plea. Is that true, or is there a new twist to this story? In the last hearing, the audio was very minimal, but I believe we did hear Michael Nowak respond to the judge at the last hearing. So whether he was there in person or there virtually, we don't know, but he was there, right? And the judge did allegedly set the case for September 6th for the receipt of some sort of plea. So Lil YouTuber said maybe he's pleading guilty so he won't be put on SOR. And that, everyone, is possible. It is possible that the parties have reached some agreement which would keep Michael Nowak, aka Brother Polight, off of the SOR. That would make sense, right? I would think if you're going to enter a plea, it might be important to you that you stay off SOR. It is a negotiation. You never know. All right. So here we are. Now you can see the playlist here. This is the Brother Polight playlist, okay? And it has every video that I have ever done on this case. It is available here on the channel. Now let's go to the very, very first video. Here we go. Let's start about here. Of the courts, right? Criminal justice online system. You see all this information in the beginning. You see Michael Nowak. You see the date this case was initiated, right? All this stuff that lets you know you're looking at the case that you're actually trying to look for, okay? So let's go past charges for a moment and let's just go here to docket, right? This is the docket report. So you can start from the very beginning here, August 17th. August 17th, you see a charging document was filed, right? And so an arraignment hearing was scheduled for September 15th. They have that it was assigned to the intake unit for these certain types of crimes, right? They have that a prosecutor was assigned by the name of Nicole Garcia, right? And then they also have that a Mr. Adam Rosen, Esquire, was given a notice of the hearing as he is the defense attorney of record in this case. August 18th, demand for... So one thing I wanted to note, I've unmuted myself just to note this, right? Remember when we said it's not extremely likely that he just walks free because he did not serve that much time to begin with. He does not have that much time served. Okay, check out the docket. August 17th was arraignment. By August 18th, he had already received bond. So again, to go to our previous conversation, it is not extremely likely because he does not have a lot of time served banked. Even for a misdemeanor, he would more than likely still have time to serve. Discovery, probably filed by Mr. Rosen or Rosen, right? Because it is commonplace for a criminal defense attorney to file a motion to dismiss, as you see here, and a demand for discovery right away. Sometimes that is referred to as an omnibus motion, right? It's an all-encompassing motion. But it is commonplace for the minute a defense attorney is retained, they say, all right, let me file my demands. Let me file my motion to dismiss. Now, here's the thing. Do they think that the case will actually be dismissed? Maybe not. But to protect themselves from malpractice, it is commonplace for every criminal defense attorney to file a motion to dismiss the charges now. Fast forwarding a bit to get to the charges. Okay, so we're going back to our same page here. See, the docket report is down here. Now, if you scroll up, you see the charges. Now, I'm going to start from the portion of this that I know all of you are just absolutely dying to hear me clarify, right? I already know. So let's start from that portion, shall we? Down here at the bottom, you see the two felonies that were initially charged along with this misdemeanor. So let's talk about this briefly. As you can see, the lowest charge here is contributing to the delinquency of a minor. To my knowledge, that is still the lowest charge. Okay, that is still the lowest charge, and that is a misdemeanor. But as we just discussed, he does not have any time served. What, a day or so? So even if hypothetically the plea agreement is the misdemeanor, he would probably still, very likely still, educated guess, have time to serve. Okay, he would probably still, very likely still have time to serve. Okay, so I'm going to hop into the chat to answer any questions before we dive into this portion, where we actually look at potential time and talk about potential plea arrangements. Plea deals. You get what I'm saying, right? Once more, the lowest charge is a misdemeanor. So if he were to plead guilty to the lowest charge, he would plead guilty to a misdemeanor, okay? And contributing to the delinquency of a minor does not put you on the SOR. So if the goal or the concern was to stay off of the SOR, the lowest charge would be the plea agreement. But remember, this is a negotiation. So it depends on the strength of the government's case. If the government has a particularly strong case, they more than likely would not agree to him pleading guilty to the lowest charge. Because more than likely, they would say, well, if we can prove a higher charge at trial, why would we agree to you pleading guilty to a lower charge? Right? But the higher charges have SO implications. Does that make sense? Does everyone get that? Okay. What is the difference? Well, we're going to get into it here. Okay. But when a defendant pleads guilty to a charge that has a SO implication, not only do you have SO registry, you have what happens after you do your time, because SOs are monitored. You have to check in, you have travel limitations. Think Nicki Minaj's husband. You have limitations on where you can live. Okay. Question from Shaka. What does reset for plea mean? Okay. So in the docket report where it says reset for plea or set for plea, that does insinuate that the case is set for a plea deal or plea agreement to be put into the record. That's the insinuation. But remember what I said, it ain't over till it's over. It's not done until Michael Nowak gets on the record and pleads guilty. Anytime before that, it could fall apart, which is another reason why we have to be very careful about the way that we discuss these cases online, which is another reason why I'm going to continuously ask you all to not come online and create video titles that say like, Brother Polight to serve 20 years. You don't know that. Stop doing that, please. So Jelly says, I was reading something about a judge having a sentencing sheet, where there's a point system for calculating how much time a person has to serve. Jelly, that is an amazing, amazing question. So what Jelly is referring to are sentencing guidelines. I'm going to put them in late chat. Sentencing guidelines. Most jurisdictions have them. And for some jurisdictions, they're public. For some jurisdictions, you can literally Google it and pull up the sentencing guidelines. But here's the thing. There's a difference between sentencing guidelines and plea deals or plea agreements. So sentencing guidelines is usually applicable, right? Mostly applicable when the judge is sentencing. But when we're talking about plea deals and plea agreements, it is a conversation between the government and the defendant. The prosecutor may use the sentencing guidelines to help guide them in the plea deal process, right? But plea agreements are a bit different, okay? Sugar Hayes says, why did the judge ask him to turn in his passport? So when you are facing these types of charges, Sugar Hayes, charges of a serious nature, the court wants to make sure that you do not try to flee, right? And so when you consider that Brother Polight is out and about, he's not incarcerated during this case, it does make sense for the court to ask for his passport to ensure that he does not try to flee the country. Let's move forward. Our doc. Let's start from the beginning, shall we? New charges. Okay, so the new charges, the new charges are all lewd and lascivious offenses. Oh, you know what? I wanted to show you Online Sunshine. So you know what? We'll do it in reverse. We'll walk through this first, and then I'll show you Online Sunshine. How about that? Okay. Alrighty. So this is all pulled from the state of Florida Online Sunshine statutes. Okay, so this is directly from the statute. All right, here we go. So lewd and lascivious, a lewd and lascivious offense is when a person intentionally touches a blank, you know, I try to stay away from certain words, under 16 years of age in a lewd or lascivious manner, or solicits a blank under 16 years of age to commit a lewd or lascivious act. Pause. So this means that a person does something intimately inappropriate to a minor or tries to do that via soliciting the minor to do those things. Now, the direct definition of lewd and lascivious is just wicked, lustful, unchaste, licentious, or sensual. That all amounts to intimate, right? The S word that we also don't use on this channel. That's what it all amounts to. Now, these types of charges are strict liability charges. Let's take a moment here because we just need to have a blank-ish child, Buddha. It's YouTube, you guys. The video will get taken down if we use certain terms. Let's have a moment here to remember some things. There is still conversation about consent and, why is he being charged? Again, many of these charges are based upon strict liability, which means there is no potential for consent. In many of these charges, it is based upon the other person / victim being a minor and that minor not being able to consent, okay? Mind you, that also applies to the parent, because I've heard some people saying that the mother may have granted some sort of consent. Again, none of that is applicable. Advised him not to contact her. That's what I would imagine, because were it my client, that is what I would have done. So perhaps he went against the advice of his attorneys on that. Okay. Some person said, Aku Cromanti said, is it even possible that it was the mother's shirt and scarf? We don't know. I'm reliving this. And before we even go down this path, let's just pause it here. Okay. So we know that L&L is what we're going to call it, is a second-degree felony punishable by up to 15 years in prison. Okay. And as we continue to go through these charges, you will see that the up to 15 years is pretty much the hallmark for the top charges here. Okay. Let's talk about legal terminology. Up to 15 years does not mean 15 years. People. Up to 15 years means 15 years max. 15 years max. So again, I've seen some people online like, Brother Polight to do 15 years. How do you know that? Do you have the paperwork? How do you know that? Up to 15 years means the maximum is 15 years. Then remember, plea deals are a what? A negotiation. There's going to be give and take because the person is exchanging their right for a trial. Okay. Now, there are multiple counts, right? And the max is 15 on the top charges. And it's 15 each. True that. But it's up to 15. And 15 is the max. Okay. Let's continue. So we know there's up to 15 for the lewd and lascivious, right? Let's fast forward. And he would have to continue to do so for the rest of his life. So I'm backing up a bit here because I want us to discuss SO registry and gain time, as you can see here. The entirety of their prison sentence. So all the other ways in which inmates can gain time, whether it's good behavior or any other rigmarole they can do working for this entity or that entity, those things do not apply to these specific charges. These charges, if convicted, you have to serve day for day. So now something to note about the top charges here. Remember, we talked about, again, the possibility that he could plead guilty and just walk away. Okay. Well, now we know one of these top charges, what we're calling the L&L, is ineligible for gain time. Okay. So in that instance, he would not even, mind you, he doesn't have that much time served anyway, but he would not be able to apply that. Okay. And we know also that the minimum is 30 months. Okay. So there's a minimum sentence of a little over 2 years. So a little over 2 years is your minimum. 15 years is your maximum. Okay, let's continue. So I'm taking you back a bit just to remind you of Online Sunshine so that you can use it to look up any cases that you want or any statutes that you want. So any type of inappropriate conduct with a minor is a crime in every state in the US, and oral contact is still considered to be inappropriate intimate conduct. It doesn't matter if it didn't involve the minor's nether regions. Okay. I do want to address this question here. So, true colors. Why is he still getting bail? Bail has nothing to do with innocence or guilt. Bail has nothing to do with the strength of a case. A person is always assumed innocent until proven guilty. So that in itself should let you know that bail and innocence are not attached. Okay, so let's go to Online Sunshine, shall we? I have it pulled up here. If you're new here, welcome. This is Online Sunshine. This is how you can view any law, any statute, anything in the state of Florida. So the purpose of us taking this walk down memory lane is to, again, discuss the top charges, the quote unquote felonies in the original charging document. Okay. Now, I could be wrong. I could be behind. And when I mean wrong or behind, I mean there could have been some superseding charging documents after this. If so, and if that changed the top charge, feel free to let me know. Okay. But to our knowledge, the top charges in this case have a maximum of 15 years and a minimum of 30 months. Okay? So again, up to 15. Up to 15 does not mean 15. It just means up to 15. Now, is it possible for him to plead guilty to more than one count? That's possible, right? But again, remember, a plea deal is a negotiation. So very often when you see plea deals, you do not usually see people pleading guilty to multiple counts in one incident. What you're more likely to see is there were multiple incidents, and so that person is pleading guilty regarding each incident. But when you have one incident and we're talking about a negotiation, a plea deal, a plea agreement, it's not extremely likely to see someone agreeing to plead guilty to multiple counts in one incident. Can it happen? Yes. Can it happen if the government has a very strong case? Absolutely. SAT-12 says, is it possible the sidebar at the hearing that was made silent for the public on Zoom was actually a plea made by Polight, but they are trying to keep it off of the media? So here's the thing. Is it possible they want to keep this plea off of social media? That's totally possible, right? But in that instance, that does not allow for the judge or the court to misrepresent what happened. So what would be appropriate in that instance would be for the court to say an agreement and or a private and or a sealed discussion has occurred. That would be fine. And they would not even have to mention what the plea was, largely because the victim in this instance is a minor, right? But to say on the record that the case is set for a plea and that a plea is to happen if one has already happened would be just a blatant misrepresentation. And I highly doubt the court would just blatantly misrepresent, because remember, at the end of the day, the public record in this case has to be accurate. The public record does not have to be all encompassing. So as I said, they can keep certain things private. They conceal certain things, especially when you have a minor involved. But there's a difference between sealing, keeping private, and misrepresenting. So for him to have entered a plea, but for the court to express that they are still waiting for a plea, that would be a misrepresentation. So that is not very likely. SMH is confirming that they take the passport. They sure do. All right. Haru Kanzu had another question. He said, if it goes to trial, would the young person have to show up in court? Well, Haru Kanzu, that depends. So in these types of cases where you have a minor as the victim, I have seen many instances in which the government, the people, the prosecutor, they try to keep the young victim off of the stand, right? And the reason for that is, quite frankly, because this is re-traumatizing for a young person. And everyone is concerned about the young person. Everyone wants to try to limit how much damage this has on the adult that person becomes. So I have seen these cases in which they go forward pretty much what is called evidence-based. They go forward with DNA and forensic scientists and detectives, and they try to limit how much they put the victim on the stand. It's possible. But I have also seen the opposite, right? I have also seen where you have a case that is heavily reliant on the corroboration and the testimony of the minor victim. And that demands that you put the minor on the stand. So it's very case specific. And also, there's some discretion there for the prosecutor to decide what he or she needs to do to have the strongest case. I have a question. Why did they cut the live stream? So if you're referring to the hearing, remember the victim in this case is a minor. So there is heightened privacy protection here. Whenever you have, let me give you a little bit of a dissertation, if you will, on privacy. So there are certain types of cases in which the victim has heightened privacy, heightened protection. First, cases that involve minors, and second, cases that involve domestic violence. The reason being is because the person who is the victim is considered to be a part of an especially vulnerable class. So if you're a minor and an adult has allegedly hurt you, you're extremely vulnerable. So you're going to get more protection. If you are a woman or a man in an intimate relationship with someone, so this person knows where you live, they know where you work, they know how to get into your house, right? You're considered to be extremely vulnerable. So you're going to get more privacy, more protection in these cases. So they may have cut the live stream because something was being discussed about the case that the court has decided for the protection of the victim, social media should not hear about. Right? And that's going to happen more often in this case than in any old criminal prosecution. Britt has a question. How many times is he able to continue the case? So a continuance is an agreement. How many of you knew that? Like, how many of you knew that to continue the case, both parties have to agree? So here's an example. If Polight's defense attorney wanted to continue the case, but the people were ready for trial, they could fight that. They could appeal to the judge and say, we are ready for trial. We do not consent to a continuance. And then the judge could decide not to grant the continuance. So more than likely, when you see continuances in criminal cases, it is on consent. It's on both parties agreeing. And this is one of those instances. Quote unquote, Brother Polight is not continuing this case unilaterally. And when you look at the docket report, you can see that. You can see that first the case was in motion status, then the case had further discovery status, then there were further motions, right? So Brother Polight himself has not been extending this case. All righty, so I got two people backstage. I'm going to go ahead and bring them up. Question from Zion Lex TV. He says, seeing that jail time was mentioned, based on the public record, is it possible to estimate the expected time served? So, I have some other people I need to bring up. So here's the thing. Could you speculate? Could you estimate? Sure, you could. Would I recommend that? No. You're wondering, why would I not recommend that? Think Tasha K. Okay? I would not recommend you try to, play prison time, guess how much time, say that you think Polight is going to have this certain amount of time. I don't recommend it at all, because with these cases, you never know what could happen. And if Brother Polight, aka Michael Nowak, does go free, he now can try to hold you legally responsible for going online and saying that he was going to prison. So I wouldn't recommend it. Okay. Okay, so anyway, welcome to the panel, everyone. Okay, let's start with SMH369. Introduce yourself and tell us what's on your mind.
No, it's Bizzle. You know, I just go by that. It's E Bizzle. You know, I'm from Chicago. My big brother, Chief X, he hit me earlier, told me when I was at the gig. So once I just got to the crib, uh, I just tuned in. I'm a little bit late, but you know what? I wanted to ask you something. And Neo X, she was in the chat. She gave a good question. What if he pleads no contest?
So, as I explained, there is a legal difference between not guilty and no contest, right? So, no contest, in essence, means I am not saying I am guilty, but I acknowledge that there is evidence against me. And so, because I acknowledge that, I'm willing to dispose of this case. That's what no contest means. Now, a no contest plea in this kind of case doesn't happen very often, right? And the reason being is the allegations here again involve a minor. And so, usually, when you have these allegations that involve a minor and the case has gotten this far, it has gotten this far because the government slash prosecution believes very strongly in the case. And then along with that comes this concern that they garner a conviction that will have some sort of recompense for the minor victim. And no contest, again, doesn't have the same implication as guilty. So it's not as likely in this kind of case.
I'm sorry, can I speak?
Oh, wait, we're going to go kind of around. So we're going to go to Chief.
Okay.
All right, Neil. So Chief X, please introduce yourself and say what's on your mind.
So, a couple people in the chat came on late, so maybe you can explain to them again why maybe they would enter a prosecutor for trial in the docket. They had that question. I think they came on
Oh,
late.
yes. So I'll repeat that answer. So there are a number of things that could be happening here. Here's the first thing. Maybe the previously assigned prosecutor can no longer handle the case. Maybe the previously assigned prosecutor can no longer handle the case, right? That's the first option. Or second, maybe the government is preparing to potentially have to go to trial. And maybe in preparation for really having to conduct a trial, they're assigning the case to someone with a little bit more experience. Because again, as I've addressed, when these cases begin, they are sometimes on the desk of someone with a bit less experience, and they're just doing the legwork. And when you really get to trial posture, you sometimes see these cases given to someone with a bit more experience. So both of those things are possible. Maybe the person left the office or can't handle the case, or maybe the government wants to be prepared if they really do have to run a trial.
Here's my question. Okay, and this is like a Hail Mary option. I'm not sure if this is possible or not, but in my opinion, Polight is a narcissist and he will gamble, right? So is it possible, I don't know how this works, is it possible that September the 6th, Polight can say, you know what? I plead not guilty. I don't want to do a plea, and let's take this thing to trial, right? Second part of the question, because he's cocky enough to do that. I'm thinking. Second part, if they do, if they set a case for trial, that means they have to convene a jury, right? So I'm thinking at that point, there's no more continuances. Am I right? Because that would disrupt convening a jury and seem like it would be some kind of contempt of court type thing. Am I off base with this?
So let's start from your first statement. So as I said, it ain't over till it's over. So yes, September 6th could come and Brother Polight, Michael Nowak, he could say, actually, it's going to be a no for me on the plea deal. And I'd like to take it to trial. That is totally possible. And then, yes, the next step for the court would be to start to impanel a jury and start jury selection and move forward with that. He has the right to a trial and he can choose to invoke that right. All right, so let's move on in the circle. I think it was actually Neo X next, right? I think so. So introduce yourself and tell us what's on your mind.
Okay, I originally was going to ask you the question about the no contest, but thank you for explaining that. But the follow-up question to that, let's just say if Polite lawyers work some type of miracle and the plea deal is something similar to a no contest plea, because somebody who, I'm not going to say the person's name, but somebody who we know who's close to Polite has been insinuating that Polite either is going to get off or he's going to get a slap on the wrist with this plea deal. So what's the chances of you if the lawyer can work some type of miracle and it might be a no contest plea?
Okay, so this would be the best case scenario for quote unquote brother Polite. The best case scenario would be the lowest charge. Remember, that's the contributing to the delinquency of a minor. That doesn't have any SO implications. There is no SO registry. And if he were to be able to plead some sort of no contest to that, that would be a best case scenario for him. And in essence, that would not have much of an implication moving forward. And I don't say that to be mean. I say that again to edify everyone and to be transparent with you, right? Because contributing to the delinquency of a minor could be giving a minor some beer. Let's be real, right? It doesn't have any implication that you did something inappropriate physically or intimately to a minor. Does that answer your question, Neil?
Yeah, I'm close enough, because like I was just saying, I was just curious because the way that the person kind of insinuated, I was like, I think he's going to get a slap on the wrist and it could be a no contest plea. But I like how you explain that in the extreme case with a minor, it's most likely the prosecutors wouldn't offer a deal like that so he can plead no contest.
By the way, Neil, that guy was lying.
What guy?
The guy, you didn't want to mention his name. He was making stuff.
Oh, yeah, he might be. But you know who I'm talking about, right?
Yes.
Okay, thank you. But thank you for answering the question, sis. I'm gonna go ahead and drop off.
All right, no problem. All righty. So last but not least, we have Mr. Zion Lex. Please introduce yourself and tell us what's on your mind.
Hey, peace, peace, peace. Can first and foremost, can you hear me clear?
Yes, we can.
Excellent, excellent. So, thank you, number one, for allowing me back on your platform. It's so refreshing to see you back on, commenting on some of the major issues going on in the community. And I'm always grateful for your commentary, your input, and your insight. Having said that, one of the pressing questions that I had as someone who knows Polite personally, who knows the mother of the alleged victim, the mother's name is Linda. Remember, when this thing first played out on the big screen, as it were, I had private conversations with her behind the scene, Linda. So I'm well aware of many things that came out later on in the court proceedings, but just speaking with the mom, I had already known many things. Having said that, one of the things that baffled me about this case is, in your professional opinion, why do you think it is that Polite was allowed to be free on the streets prior to arbitration or arbitrary proceedings? Is that normal? Could you kind of explain that for some of us who don't really understand that part?
Absolutely. So usually with these types of charges, these are serious charges. These are charges of a serious nature, right? It is not the usual nor the norm for someone to be facing this nature of charges and then be given bond as quickly as Polite was given bond, right? It's not that bond is impossible, but like I said, we saw a day or two before he was given bond. That was a bit odd. And it has been said that that was some sort of clerical error. It has been insinuated that was some sort of error on the part of the court system. And that's possible. Errors do happen. I hate to give anyone nightmares, but people are released early accidentally all the time. So errors do happen in the court system. And perhaps that was what happened in this instance, because with charges of this nature, to have been granted bond so quickly is not really inside of the norm.
Okay, my last question for the moment, as a follow-up to the first question, is are you aware of a statute either making its way to Florida or already passed in Florida, where they're looking to give men or women convicted of crimes against children, especially related to the aforementioned charges, they're looking to give them either life in jail or, worse yet, the death penalty. Has that come to your ears yet?
No, I have not heard of that. But I will say that I have heard, and this was a while ago, that there was a consideration about escalating people with a history of this type of, right?
Okay.
So, you know, as we've discussed here, I talk about this almost every video on this case. Usually when you're charged with a crime, your past cannot be used against you unless they can argue that you have a pattern of behavior, right? Someone said in the chat, you have a modus operandi. So what I have heard is a discussion about a law that centers around pattern of behavior and people with a pattern of SO behavior, and using that to escalate the sentences that they are given in new offenses. So in other words, if you have had 2 previous SOs and now this is your 3rd SO, it's kind of akin to how they used to have that whole 3 strikes situation, right? You've had 2 previous SOs. Now this is your 3rd or 4th SO. You would automatically be on the higher end of sentencing due to it being your 3rd or 4th SO. Now, that's not to say that the system does not already have schematics kind of like that already, right? Because remember, we have the sentencing guidelines, and you're always on the higher end of the guideline when you have a record of any sort. But what I've heard is stricter punishment and guidelines specifically applied to patterns of SO behavior.
Can I be heard?
Yep, we can hear you and see you.
Okay, great. Thank you for doing this, first of all. My question would be, in cases, I know you can't speak to the specifics exactly, but in cases where you have say, bedroom allegations, I'll justify it that way, where they have genetic identification traces back to the defendant, what would be a reasonable justification for that happening that the defense team might possibly try to convey, if that makes sense?
I get your question, and I will answer it like this. I will not say reasonable. I'm not going to say what justification would be reasonable, but I will tell you some that I have heard. And I'll tell you you know what, I'll go with the main one that I've heard. I have heard quite a bit the idea of DNA transfer. I've heard that a lot in cases that have genetic evidence. And the most prominently, we heard that at length when Nicki Minaj's brother, if you guys remember him, I don't know if do you know what happened with Nicki Minaj's brother?
Vaguely.
Okay. So for those of you who don't know, Nicki Minaj's brother was charged with SOing his stepdaughter, who was, I think, 12 at the time. And there were some similarities between that case and this, in that a large part of that case was genetic evidence on her clothing and I believe in her underwear. His defense attorney argued that there was genetic and DNA transfer from the mom, right, which sounds similar to what we've heard, that ended up on the daughter's clothing. They argued that via the exchange of clothing between the daughter and the mother, and also via the clothing being put together in like the same dirty clothes hamper and all being washed together and melded together, that somehow there was DNA transfer from the mother's clothing to the little girl's clothing. That argument did not work.
Okay. Yeah. Sorry.
No, I was saying he was convicted. It did not work.
Okay. And lastly, I would say, I know that, and correct me if I'm wrong, Mr. Polight did receive bond, obviously. What would have been used, or what's most prominent in cases similarly to this one that would preclude him to not receive bond, if that makes sense? Because if we have the evidence that we just spoke about amongst the other allegations, what do you believe they did not have, or why was he able to receive bond, if that makes sense?
So, there's a number of things. So it's a balancing, it's a weighing, a tipping of the scales. As I said, it could have been a clerical error, right? Because that was the initial statement from many folks, was that there was an error that led to him receiving the bond. So that's the first thing. But if it wasn't a clerical error, the court could have considered a number of things. The court could have potentially considered his criminal history, because to my knowledge, he did not have a record that consists of this type of incident, right? So the court may have considered that. The court could have considered what evidence was available at that time, because I'm not sure that at the time of arrest they had the full DNA analysis yet, right? Again, could be wrong on that, but I don't think they had the full detail there yet. So there's a couple of things the court could have considered. One, past history. Two, what evidence was at hand at that time. But that's only if it was not an error, because as we've said, it could have been. And believe me, those types of clerical errors happen all the time. Defendants are released accidentally. The wrong bail or wrong bond is set because someone put a 0 in the wrong place or a 2 in the wrong place, all the time.
Okay. That makes a lot of sense. Do I have time for one more question?
Yeah, one more question, then we'll go to Claymore.
Okay. One more question. In your opinion, why does it such a large disparity amongst defendants receiving bond or not receiving bond based on the reputation or of the legal team that they have, or the representation that they can afford? Do you understand the question, so to speak?
I understand the question, and I think it matters what representation you have, right? But only to a certain extent. So I think that if you have more robust representation, especially at the early stages of a case, yes, you could increase your chances that you receive bond. I think that's true. But ultimately, even defendants with less robust representation, they would at some point in the case be released once the case continues to drag on and drag on and drag on. So could it possibly assist in someone receiving bond earlier? Potentially, if you have really robust representation. And why is that? I mean, it's simple. A judge is a person. And so what the judge is looking for is a solid argument that gives them backing for the decision that they make. So if your legal team, your representation is not making solid arguments and they give you bond, that doesn't look good for them because there's no backing there. So if you have robust representation, your representation makes a good, solid argument for you to receive bond and be released, then the judge can say, okay, I made this decision based off of this argument.
Okay, makes sense. Sometimes it seems like robust representation is almost synonymous with financial affordability of the team that you can retain. So,
I mean, in some instances it is. But here is the thing that a lot of people don't know about criminal defense. And I saw a video yesterday of Mace, and Mace was saying all money isn't good money. And I couldn't agree with that more. So there are certain types of law like family law and criminal defense. I don't care how much money they're paying. I'm not doing it. I'm not doing it. So criminal defense attorneys deserve every dollar they get. They have stomach ulcers. They struggle with alcoholism. They struggle with drug use. They're on call 24/7. Mm-hmm. There's no Christmas. There's no weekend. There's no vacation. Why? Because guess what? People get arrested more on those days than the regular day. So yeah, money will help you have a better legal team, but they will earn every dollar. They will work for every dollar you pay them because it's akin to slavery.
Yeah, well, thank you for taking my questions. Those lawyers, they chose that path in many cases. Not all, but most of them. I have to believe that, but you know better than I know. But I'll get off and thank you for taking my questions.
All righty, no problem. Claymore Jones, how are you and what's on your mind?
Hello, Esquire, can you hear me?
Yes, I can hear you.
I want to ask two questions. I remember hearing that the prosecutor said they came to a plea agreement. So does that mean that the negotiation process is over now and Polight knows what's in the plea and he's kind of accepted it but hasn't accepted it in front of the judge yet, but he does know what it is? And number two, was the mother and the alleged victim consulted about the plea agreement?
All righty. So I love that question. So if the prosecutor has represented on the record that they have reached an agreement, yes, that insinuates that there is already an agreement reached. That would mean that, yes, Polight and his attorney, they know the details of that agreement. Now, the part of your question that I really loved is where you said, okay, was the victim and her mother, were they consulted So technically, it is the right thing to do. It is the appropriate thing to do for the prosecutor to consult the alleged victim or victims before reaching a plea deal or plea agreement. That's the right thing to do, and it's considered to be the ethical thing to do. However, there is no rule written down anywhere. There is no statute written down anywhere that says that you need the approval or the review of a victim in a criminal case to take a plea deal.
Okay.
So it's one of those lines where it should happen, but it does not always happen. And sometimes, even when a victim expresses discontent, a deal could still go through.
Okay. Okay. Thank you. That's all I wanted to ask you. Thank you so much.
All right. I'm looking for questions in the chat. I don't see any questions per se, unless I missed something. If you have a question, let me know. Because if not, I'm going to head out of here. So I'm going to give you all, let's see, a minute or so. If you have any questions, plop it into the chat. Otherwise, we are going to go ahead and get on out of here. Okay, so question. If he went to trial and the DNA comes up, he might attempt a conspiracy theory on how his stuff got onto her scarf and her shirt. It seems to be a very hard sell to the jury. As I said previously, in the past, trying to argue away DNA in these cases has been a hard sell. I've seen it done. I have yet to see it be successful, right? Attorneys argue things like DNA transfer or that the lab is not as professional or impartial as they should be, or that that particular scientist cannot be trusted. They argue all sorts of things, and it isn't very often that it makes it. Gary has an interesting question. So Gary says, what would you say to Polight if he is listening? I would say to him the same thing that I would say to any defendant in this position. Listen to your attorney. That's it. You have an attorney. You're lucky to have one that is private, right? So you should be of higher priority, if you will. Listen to your attorney. Jabari is saying that it has been said that the most serious charges have been thrown out. Interesting. Can you clearly explain how pleading guilty does not mean that? Oh, wow. So that's an interesting thing. So if a charge has been quote unquote thrown out, that would mean that charge has to be dismissed. Thus far, we haven't heard that. However, what we could hear with this plea agreement is we could hear Polight pleading guilty to a lesser charge or a lower charge on the document. And remember, the lowest charge we saw was contributing to the delinquency of a minor. There's a difference between higher charges being dismissed and a plea agreement being reached, which notes a lesser or lower charge. Those two are not necessarily the same, right? Now, what could happen due to the plea agreement is, again, he could plead guilty to the lower charge, and the people could choose to dissolve of the higher charges. All right. Sat 12 said, is it possible that a plea will be made to a revision of charges, different charges we haven't seen yet? That is possible. You know, again, almost anything is possible. No, but really, that is possible. That is possible. Okay. Big Hamza says, is there a chance that Polight rejects the plea deal? Being that it's been represented that they already came to an agreement, maybe not. You know, but as I said, it's not over till it's over. You know, he can always try to implement his constitutional rights, argue that he wasn't properly informed, argue that he's being taken advantage of, and say that he wants to reject the agreement. All right, so I do not see anything. Texas Bama says, I'm a dog. Thank you. Alrighty, so I don't see any other questions in here per se. Alrighty. I think Mr. Cleanup Man is asking a question that we've kind of already answered, so you may want to take it back a bit, Mr. Cleanup Man. All right. Listen, I've been in here for almost 2 hours. Rarely do I ever do a 2-hour live, okay? But it's been a while, so I wanted to make sure that I give you guys the time that you deserve, right? And by you guys, I mean of all genders and all identities, right? Please do not take that as non-inclusive language. I love you, okay? So listen, this has been another installment of Empowered Esquire podcast. So listen, if no one has told you today, I love you. I mean that. And you bring something unique to this world, to my life, to my channel that no one else does. All right? See you soon.